Welcome to another TDW Tech Bite. This is an introduction to a new series of Tech Bites we're going to do on the pending changes and reform to personal data privacy laws in Hong Kong. So on the 20th of January of this year, a paper was presented by the Privacy Commissioner to the Hong Kong government, which outlined 6 key proposals for change to our data privacy laws. These changes and reforms are long overdue. In fact, it's the ripple effect of GDPR finding its way to this part of Asia. GDPR has already driven changes in a number of locations, and in fact within Asia Pacific generally, either new legislation is on the cards or has recently been introduced in a number of jurisdictions, in places like Singapore, Thailand, Philippines, and now also coming through in Hong Kong. Each of these 6 areas of change we will feature in a forthcoming TDW Tech Bite. But in this session, I want to give you an overview of those changes, let you know where we are, what's coming down the pike, and what is the timeline for preparing ourselves for this particular change in the laws. So what are the changes? And why are they needed now? So the reason they are needed now is because the world has changed significantly, particularly in terms of technology and the use of technology and people's expectations in respect of personal data privacy since the last set of reforms that were introduced in Hong Kong in 2012. In particular, in those intervening 8 years, we've had the advent of AI and big data and the additional ways in which personal data is used by ad tech companies, and the way that data processors are now almost the norm rather than something that is more occasional or exceptional. And these are the drivers for change. The standards are higher elsewhere, and because the standards are higher elsewhere and data moves, those standards are also exported and become the expected standard in other places in the world. So what are the changes that are coming our way here in Hong Kong? Well, first, the definition of personal data itself is going to change. It's going to move to a definition that is quite similar to the definition that is used in GDPR. The consequence of that is that it is likely to sweep up certain kinds of data that are presently excluded. This will have a direct impact for those who operate in the ad tech world, where you'll find that cookies, for instance, are likely to be swept under the regulation ambit of the Privacy Commissioner. We're going to have a mandatory breach reporting regime introduced. That will mean that if there is a personal data breach, and it is something that is serious or material to the interests of data subjects, then the data user, that's a data controller in GDPR terms, will need to report that to the Privacy Commissioner within a prescribed period of time. Now, that prescribed period is likely to be 5 working days, so a pretty short period of time, and businesses will need to prepare and align to that timeline. Next, there's going to be an administrative fining power that can be administered by the Privacy Commissioner directly. This is something that's long overdue. Up until now, the most that the Privacy Commissioner could typically do is to inquire and investigate, make recommendations, or deliver an enforcement notice, and it was only if the enforcement notice wasn't complied with that the Privacy Commissioner had various powers in relation to compelling compliance or having fining authority, and penalties would follow. That is going to change. It may not be to the same extent as the sweeping fining powers under GDPR, but it will be a significant advance to the current situation. Experience in other locations has shown that fining powers are indeed a good tool to have in the armament of regulators. The next change is a change in respect of data retention. The best protection against the loss of personal data is not to hold the personal data in the first place. And that is something that can be assisted by virtue of having good and proper data retention policies in place. Now, the range of personal data that businesses hold is too broad and vast to be prescriptive about the period of time that the personal data should be retained. but instead the change is going to be that businesses will be required to have a document and data retention policy. So businesses will have to focus on the issue and define what their policies are in this area. Significant improvement. There will also be direct regulation of data processors. Until now, the regulation has been indirect in that data users were held accountable for the acts of data processors in particular areas of the data protection principles. That is going to change, and the Privacy Commissioner will be able to directly enforce against data processors in prescribed circumstances. And the final change that will be made will be in relation to the offense of doxing. And the Privacy Commissioner will have broader powers to be able to direct the changes and removal of personal data that has been publicized by virtue of a doxing offense. Now, are these changes good? Yes, they're all good. They're all good. In fact, the only reservation you might have is that you might wish that there were more. There are other things that are not being proposed that would further enhance the personal data protection regime in Hong Kong. Things like the accountability principle, where requiring, for instance, as in Singapore, where each business of a particular size must appoint a data protection officer. That would give a focal point for the regulation to take effect and also create a position and office within each business, which would ensure that personal data privacy was at the heart of what that business did and conducted. Certain GDPR rights that are still not yet there. For instance, there isn't a right to be forgotten or a right to request the deletion of personal data, and there isn't a right being proposed in respect of data portability. Nor is there a proposal in relation to a special category with special protections for sensitive personal data or for children's personal data. So yes, there's more to do, but these are significant improvements, and I'm looking forward to exploring these improvements in more detail with you in the next and follow-up series in this session on personal data privacy change that is coming in Hong Kong. Remember, forewarned is forearmed. Listen in and you'll know how to prepare more and to prepare better.